Good morning, everyone. My name is Avi Kellen. Welcome to Quimbee CLE. Today we're going to be talking about the promise and peril of corporate political activity compliance. Before we jump in, just a word about me. I'm an attorney with a law firm of Genova Burns, which is headquartered in Newark, New Jersey. I focus on corporate law, political law, and I chair our firm's autonomous vehicle law practice group, but we'll leave all that stuff to the side for now and jump right into political activity compliance. We're going to cover today a few topics. We're going to give a political activity overview, define what that term means and what is counted as political activity. We're going to review federal campaign finance law, the campaign finance laws in various states. We're going to dive into pay-to-play restrictions, which we'll get into more later on, but this is really the intersection of government contracting and political activity. We're going to review ethical interactions with elected officials, and finally, we're going to review strategies for compliance. So what is political activity? It includes a lot of things. That includes making a direct political contribution, right? Giving money to a political candidate, giving money to a PAC, a political action committee, or a political party. And that also includes making an in-kind contribution. So, so anything of value that you provide to a political recipient doesn't have to be a check or money. If I give goods or services, if I give free legal services, if I buy food for an event, if I let a political candidate use my van on election day without charge, that's all the provision of goods and services, and those are treated as in-kind contributions. Soliciting contributions, also asking other people to make a political contribution, that is also political activity that we're going to be reviewing today. And then a couple items that people are sometimes confused about. If you purchase a ticket to a political fundraiser, if that's a golf outing, a cocktail party, that is all political activity. The full price of your participation in that political event counts as political activity. This is different than sometimes you see in the charitable context, where only a certain amount of the purchase price for your attendance at a dinner is counted as a charitable contribution. In our case, when it comes to political activity, if I pay $500 to sponsor a golf outing, the full amount of that $500 is treated as a political contribution to the candidate, and you can't deduct out any operating costs or things like that. Last, placing an ad in an ad journal in connection with a political fundraiser, that is all. You may think of that as just networking or marketing. That's all political activity and is treated as a political contribution under campaign finance law. So let's take a step back now that we understand a bit about what is political activity. Let's think about the theory of what this is under U.S. Supreme Court jurisprudence. So the key case in this area is Buckley v. Vallejo from 1976, and the court in that case, was dealing with a raft of new campaign finance and ethics laws in the wake of Watergate and the wake of some political corruption scandals. And so Congress passed many new laws, and the Supreme Court was asked to weigh in on whether that activity, those new laws, violated the First Amendment guaranteeing free speech. And the Supreme Court took this in an interesting direction. It said that political speech and limitations on political speech really operate in an area of the most fundamental First Amendment activities, right? Congress can pass no law to abridge speech, and political speech is really one of the most important areas of that First Amendment protection. Therefore, the Supreme Court said, Congress is prohibited from passing any law that limits what candidates for office may expend on a campaign, right? If the candidate can raise money from enough people, they can spend all of it. There's no limits on expenditures that a candidate may make for their campaign. By the way, that's different in different countries. In other countries, under their systems that don't have the First Amendment, a candidate can be limited to say, you can only spend $5 million on this campaign. You can only spend $10 million on this campaign. On smaller races, you can only spend $400,000 on this campaign. In the United States, we have no such law because that's what the Supreme Court said in 1976. The only limitation on what Congress can pass to limit political speech is as follows. The only reason that we can limit political speech is to prevent corruption or the appearance thereof. That's the only reason. And so with that, that's why we have in basically every state, or most states, I should say, and in for federal candidates, there are laws that say you can only contribute up to X amount to this candidate. And the worry is that if I contribute $10 million to a candidate for Congress, or to a candidate for president, or to a mayor or a governor, that's too much. That large amount of money is necessarily going to engender favoritism and corruption. And so it's permissible for Congress and the states to pass laws that limit what a candidate may accept, what a contributor may contribute directly to candidates. That's the only thing that is constitutional under Supreme Court jurisprudence.